In 1981, the UDDA, or Uniform Determination of Death Act, was meant to represent death as a biological occurrence, which is why the words irreversible cessation of all functions of the entire brain, including the brainstem, were chosen. On July 26, 2023, a proposal went before the Uniform Law Commission about changing the legal definition of death in America to reflect what doctors are already doing. In other words, doctors are already diagnosing death by neurological criteria according to standards other than the law. Lawsuits have been brought against doctors and hospitals because families have recognized that doctors did not fulfill the requirements of the current law when diagnosing their children or family members as brain dead. Doctors have asked the Uniform Law Commission to change the law to reflect current practice and avoid these lawsuits. For the past 3 years, lawyers have been working to revise the UDDA with updated language to reflect only partial loss of brain function as legal death, the standards doctors are already using, without the law backing them up. In 2015, a young woman named Aiden Halou was diagnosed with brain death, and her father took the hospital to court over her life. After a fight through the district court, the Nevada Supreme Court determined that the widely used practice of the American Academy of Neurology standards to determine brain death did not align with the UDDA's standards of irreversible cessation of all functions of the entire brain, including the brainstem. However, doctors continue to use these standards. That brings us to a few days ago, on July 26, 2023. I'm Dr. Heidi Klessig, and I'm a retired anesthesiologist and an observer to the Uniform Law Commission as they seek to revise how death is determined in the United States. On Wednesday, I watched the 3-hour live stream as lawyers presented the first draft of the revised UDDA. Even after 3 years of work, the drafting committee was unable to agree on what changes should or should not be made. So they presented 2 options for discussion at the Uniform Law Commission's annual meeting in Honolulu. Option 1 is to keep the current UDDA definition of death. An individual is dead if the individual has sustained either irreversible cessation of circulatory and respiratory functions, or, if your heart is still beating, irreversible cessation of all functions of the entire brain, including the brainstem. Option 2 changes the term irreversible to permanent and requires only partial loss of brain function to be considered legally dead. Option 2 reads that an individual is dead if either they have permanent cessation of circulatory and respiratory functions, or, again, if your heart is still beating, permanent coma, cessation of spontaneous respiratory functions, and loss of brainstem reflexes. During the hearing, Professor Nita Farahany described the change in language from irreversible to permanent as follows. Irreversible means cannot be changed. Permanent means will not be changed. In short, this means that you can be declared legally dead because doctors are unwilling to intervene on your behalf. This would allow the same person with the same brain function to be declared either dead or alive entirely based on their doctor's intentions. So what are these permanent states? The first is coma, which is defined as a state of sleep-like, unarousable unresponsiveness. It isn't the same as the loss of the capacity for consciousness, and there are countless stories of people who have woken up from comas describing more awareness than people expected. There are currently no actual tests for consciousness. Doctors can only test if you are willing and able to respond. And in the early phase of brain injury, known as cognitive motor dissociation, patients are aware and inwardly conscious, but are unable to respond. This means permanent coma isn't a reliable diagnostic feature at all, just an educated guess. Second, permanent cessation of spontaneous respiratory function, which means you're on a ventilator, so how can you tell? The apnea test, in which the patient is removed from the ventilator for up to 10 minutes and observed for breathing, is part of the protocol for brain death testing. But it does not reliably answer whether a person will eventually start breathing again on their own. It's also an ethically controversial test because it does nothing to help the brain-injured person, even potentially causing more brain injury, and only serves unspecified others who might need their organs or their ICU bed if the patient fails to breathe. In other words, it can harm the patient and doesn't even reliably answer the question in the first place. Finally, permanent loss of brainstem reflexes, which is a change from the current standards, which include the entire rest of the brain. This new standard ignores everything above the brainstem, using that as the only determination for its function. This means that people who have electrical activity on their EEG or continued functioning in parts of the brain above the brainstem can be declared legally dead after only a brainstem reflex test. The current UDDA is more protective for patients whose prognosis may be death but still have brain function from being declared legally dead too soon and removed from life support. However, patients have recovered even after being diagnosed according to the 1981 UDDA standards, meaning this, which isn't even being widely followed, clearly isn't enough. So what's the good news? The Uniform Law Commission wasn't able to come to a conclusion on the new proposal and has sent it for another year of study, meaning the current law still holds despite common medical practice. That means that you and your family have a right to request that the full and current UDDA standards for death determination are used. The bad news is there is currently no opt-out for these standards unless you live in the state of New Jersey. In the new proposal, an opt-out section has been added, letting anyone object to a determination of death by neurological criteria, provided the objection is made before beginning the clinical evaluation of brain death. But in order to object, you have to know that this is a concern to begin with. So to summarize, the commonly used medical guidelines for determining brain death do not align with current U.S. law. This could allow people with partial brain function to be declared legally dead and therefore lose any and all civil rights. The current and proposed laws do not provide adequate informed consent to the public about being declared legally dead by neurological criteria. Unfortunately, America has a history of treating the lives of some as more valuable than others, and the lack of informed consent about these issues allows the powerful and informed to take advantage of the disadvantaged and unaware. So what can you do? First, spread the word about the current and proposed Uniform Determination of Death Act, so informed consent is a public option. Second, have an advance directive in your medical records stating that you refuse to be declared legally dead by neurological criteria. Third, write to the Uniform Law Commission saying that you, as a United States citizen, oppose the revisions to the UDDA. And fourth, advocate for a new opt-out on the current UDDA for both patients and medical practitioners. This information isn't hidden, it isn't secret, it just isn't well known. Brain death is a hotly debated topic in medical, legal, and philosophical journals, but the greater public remains largely in the dark. Everyone deserves informed consent about their medical rights, and the only way that happens is if we talk about it.